Greetings, everyone. Thank you for joining us today. My name is Sandra Haltom. I am the Secretary of the American Constitution Society Houston Lawyer Chapter. And today we are going to be talking about a very timely topic of voting rights with two experts on the subject, Danielle Lang and Chad Dunn. As a brief overview of ACS, we are a national, nonpartisan, nonprofit C3 organization focused on ensuring that the law is used as a force for good and to protect people's and improve people's lives. And our membership is made up of lawyers, law students, scholars, judges, and policy experts across the nation. So if you are not already an ACS member, we would greatly appreciate if you would join us and become part of the team. So now an introduction of our lovely and talented experts. So Chad Dunn has many hats. He is a partner at the law offices of Brazel and Dunn in Austin, Texas. He is the general counsel for the Texas Democratic Party. And also, I recently learned that he is the policy director at the UCLA Voting Rights Project. So, wow, you're very busy, Chad. And then Danielle Lang is the co-director of Voting Rights and Redistricting at the Campaign Legal Center. And once we get started, I'll put links to all these different organizations in the chat so that you can all check those out. So hold on one second. Let me just make sure that everything is rolling correctly here. All right, so we will be recording this as well. So if you are not able to attend the whole thing, as I know some people were not going to be able to, then you will have an opportunity to watch it later. Okay, let's see. All righty. One second. Okay. All right, so let's get started. So some background on the topic of today's discussion. So the Texas primary was held on March 3rd of this year, after 2 weeks of early voting, which we had in late February. Around that time, the coronavirus was starting to be a thing that people were talking about, but it was still sort of an abstract thing that wasn't really impacting us here in the United States. So then 10 days later, on March 13th, Governor Abbott declared a state of emergency due to the coronavirus as things had picked up. So Texas was supposed to hold a runoff on May 26th, but the governor pushed that back because of the fears of coronavirus and concerns about people being in close proximity with each other. So now, with cases in the state spiking, and I believe yesterday we had 6,000 cases reported, which was the largest so far in one day, we are facing a runoff election on July 14th with early voting scheduled to start Monday. So in that context, let's talk about what has been happening so far to try to keep people safe from coronavirus while voting, and also what is expected to happen between now and the start of early voting and election day, and just kind of what folks should expect if they choose to go to the polls in person. So Chad, let's start with you. Apparently the thought that people might need to be protected from catching the virus while voting in person occurred to you as well, and you and the Texas Democratic Party and some other folks filed a lawsuit to try to keep people safe. So tell us a little bit about how all of that transpired and what is going on with that litigation.
Well, sure. Thanks for having me, and welcome to everyone. It's good to see friends here. So it would take a couple of days to lay out what's already happened in our vote by mail saga. So I'll do a super abridged version. But sometime in March, late March, we began to learn of reports. Well, let me back up on the primary day that you referenced. We got reports that day of voters who were afraid to go vote. There was a number of election workers that wouldn't show up for their shifts because they were concerned about contracting the coronavirus. So we realized immediately there was going to be an issue and began to work on that. We had discussions with the Republican Party about trying to work out an agreement on vote by mail that included the Secretary of State's office. We never really got any pushback from the Secretary of State's office, but ultimately the Republican Party wouldn't agree to some kind of process for a larger scale vote by mail. So the rules in Texas as they exist, as the legislature passed them prior to the pandemic, is that people who are disabled can vote by mail, and disability includes pregnant women. It also includes, according to the Attorney General, sexual deviants who are supposed to stay at home and not be around others. And so we thought the definition was broad enough to cover people who did not have immunity to COVID-19. So the first step was to ask state courts to clarify what state law provided. We filed a lawsuit in state court. We were joined by a number of partners, including the Texas Civil Rights Project, the League of Women Voters, the ACLU, and others. And through one of the more complicated appellate processes I've ever seen, a couple of mandamuses, some appeals, some stay motions, and a number of interventions. Ultimately, the Texas Supreme Court issued a ruling that clarified that lack of immunity to COVID-19 alone does not qualify you to vote by mail under the disability provisions. But the Texas Supreme Court did say that the ultimate determination is up to the voter, and that the county officials cannot question what the voter puts on their form. So if the voter checks the disability box, they have to get a vote by mail a ballot sent to them. What happens after that, if some authority determines that they weren't entitled to vote by mail, is left unanswered by the Texas Supreme Court opinion. Ultimately, this is it looks like this is something that will be dealt with on a local level, assuming that remains the rule. The reason I say that is because in addition to the state court case, we identified some federal constitutional problems with Texas's administration of vote by mail. The most central of these is the 26th Amendment, which provides that the right to vote cannot be denied or abridged on the basis of age. So the language in the 26th Amendment matches the language in the 24th and the 19th and the 15th Amendment, all of which use this abridged language. And those other amendments have all been construed that abridged means a comparison. And in other words, it's not okay to give one sort of voting vehicle to some group of people and not give it to another, and use age or gender or the payment of a tax or race as the sort of the trigger. So anyhow, we filed a lawsuit in federal court that sort of tracked along in terms of timing with the state court case. The federal judge issued an injunction on May the 18th, finding that the state allowing people to vote by mail over the age of 65 without excuse, but requiring an excuse of people under the age of 65, violates the 26th Amendment and other provisions. The state was dissatisfied, to say the least, with that ruling, so they filed an appeal, and they also asked the Fifth Circuit to stay that injunction. The Fifth Circuit obliged them and issued an opinion about 2 weeks later that stayed the injunction. And now, absent some other event, the Fifth Circuit appeal continues on the actual injunction itself. So the stay's been decided, but whether or not the injunction could have been entered has not yet been decided. The state's brief is due on that June 29th. Promise I'm getting to the end. So the next step was we filed two things with the United States Supreme Court. One of them is an application to lift the stay. That's filed with Justice Alito, who's the justice assigned to the Fifth Circuit. What we typically see in cases of this nature is Justice Alito would refer it to the full court. So the expectation is the full court would rule on it. He can rule on his own, though. If he does, then we're allowed to go to another justice and ask another justice to lift the stay, and that justice would be required to refer it to the court. So my expectation is at some point that gets decided by the whole court. The briefing was complete on that on Tuesday. So The court's had it since then and hasn't ruled. I view that, I've had a few of these in my career, these stay applications to the U.S. Supreme Court. All of them were denied within a few hours, certainly within 24 hours. So the fact that this has taken a little time might be some good news. Then again, it could be it's the end of the term. The Supreme Court's punching out a bunch of merits decisions and it hadn't gotten to it yet. But regardless, a ruling could come at any moment. And in addition to that, we have also filed what's called a petition for writ of certiorari in advance of judgment. And we're essentially in a motion to expedite consideration of that. We're essentially telling the Supreme Court or asking the U.S. Supreme Court, if you lift the stay and the injunctions in place, then you should take this case and excuse me, and find that the Fifth Circuit's analysis is wrong, and you can do that in the normal course. If you don't lift the stay, then you should take the case immediately, have briefing over the summer, and decide the case in time for the November general election. So that's the circumstances of things, and we're waiting on rulings of both of those. The last thing I'll say about it is that the Fifth Circuit decided in its opinion that the 26th Amendment is essentially surplusage, that it doesn't do anything. The law prior to the 26th Amendment was that age discrimination in things like voting was decided on what's called a rational basis. And the ratification of the 26th Amendment, according to the Fifth Circuit, didn't change that. We think that's wrong. Every other court to look at it has ruled differently. So that's sort of the central legal question for the Supreme Court.
Wow, that's a lot for just a few months.
Yeah.
You've been kind of busy. So Danielle, how did Campaign Legal Center get involved in the litigation going on here in Texas?
Yeah, thank you for asking. Well, of course, we always like to work closely with Chad Dunn, who doesn't. But when we saw the federal case moving forward, we thought it was really important to make sure that the issues around race and the impact of the age restriction, especially in Texas right now during the coronavirus epidemic, what it was going to mean for Latinos in Texas was a really important angle for the court to be aware of and thinking of when they make these, life or death in some ways decisions about how we're going to be voting in the next couple of months. And so we represent the Latino United Latin American League of United Latin American Citizens. It's a mouthful sometimes. And tried to intervene in the case with the idea of pressing, in particular, issues around Section 2 of the Voting Rights Act, and really looking at how the 26th Amendment issues are going to have an obvious racial effect. And all you need to do is know the tiniest bit in Texas to know that if you have a rule that says people over 65 can vote by mail, no problem, and everybody else needs an excuse, that there's going to be an extreme skew in the racial impact of such a rule, with Latinos being wildly disproportionately represented in the under 65 on Latino individuals and Latino communities in Texas. The impacts are extraordinarily severe. While our motion to intervene was actually denied by the district court because of kind of how close it was to the district court deciding the ultimate issue, the district court did findings about the impact on the Latino community that we think is really important, that need to be continued front and center as the Supreme Court considers this issue, as the Fifth Circuit considers this issue, and unfortunately was completely ignored by the Fifth Circuit decision.
Gotcha. So Danielle, are y'all involved in similar cases in other states?
So CLC has been very active, along with all of our kind of peer groups right now on voting rights, trying to safeguard vote by mail. And what does that mean? It means not only safeguarding access to vote by mail, like unfortunately, sorry about that.
That's okay.
So that means safeguarding. That means safeguarding access to vote by mail for places like Texas that are trying to make it hard for people to vote by mail. Maybe people are actually going to get their ballots, and that they're easy to submit, so that making sure that kind of the process of submitting absentee ballots is as easy as possible. And then on the back end, making sure those ballots count, right? And so in Tennessee, we have a case that actually kind of covers all of those issues. It challenges restrictions on who can vote by mail. and kind of the sharp restrictions are very similar to the ones in Texas are in Tennessee. Luckily, they have been stayed by a state court right now in Tennessee. We've also challenged a criminal prohibition on distributing vote by mail applications. So not unlike voter registration criminal restrictions in Texas, which make it very difficult to help people register to vote in Texas, Tennessee has actually made it a criminal offense to hand out a vote by mail application, a blank one, to your neighbor, unsolicited. And so we have challenged that as a as an unlawful restriction on First Amendment activity. That's supposed to make vote by mail easier for the community by letting community groups help people get their vote by mail. And then on the back end, making sure that there's a notice and cure process if there's a problem for your ballot. Right now in Tennessee, your vote by mail ballot has some sort of technical error or signature mismatch, they just throw it out. And that's a clear procedural process problem. We have similar cases on signature mismatch in North Dakota and New Jersey. We've also challenged a witness requirement on your absentee ballots, another thing that makes it more difficult to vote mail in Minnesota. And I think you can expect from CLC and others for these types of cases that are about kind of enabling vote by mail to continue to rack up in the coming days, weeks, and months.
Well, thank you for all that you guys are doing to help voters across the nation vote safely. We appreciate it. So this question is for either of you. So as I understand it, the main issue that's still at play in the Texas mail ballot case is the 26th Amendment. So tell me a little bit more about the argument that you made to the courts and why you think they're wrong in their determination.
Danielle, you want to take that or you want me to?
Why don't you go ahead and start? It's your case, and I'll pipe in if I have anything else to say.
Okay, well, so brief history of the argument over both the 26th Amendment and vote by mail is there's a U.S. Supreme Court case from 1969 called McDonald, where a group of inmates in Chicago, I believe, were trying to secure vote by mail because they were incarcerated. And so they filed a lawsuit. When it ended up at the U.S. Supreme Court, this was not an age-based restriction. And of course, this case was before the 26th Amendment had even been ratified. And instead, they claimed that under the Equal Protection Clause, they were entitled to vote by mail access given their incarceration. And the U.S. Supreme Court, and really a decision that's an outlier from the Marshall Court at the time about voting rights, determined that the case was speculative. Essentially, the state was claiming it was going to make an in-person voting location available in the prison and was going to facilitate prison voting. And on those representations, the court decided that the prisoners couldn't show a harm, that you didn't have a right under the Equal Protection Clause to vote by mail. You only had a right to vote, and if the state facilitated it in some way, then that cured the constitutional harm, if there was any. So that was the case. And in 1971, the 26th Amendment was ratified, which doesn't speak to vote by mail specifically. Instead, it speaks to denial or abridgment of the right to vote on basis of age. But since then, as far as I'm aware, there's no vote by mail case that has been brought and has been decided by the courts of appeals of the U.S. Supreme Court or state Supreme Courts, for that matter, on the age restriction. So in that way, the Texas case is unique. But there have been a number of other 26th Amendment cases. There's one out of the First Circuit. There's one out of the California Supreme Court. There's one out of the Colorado Supreme Court that include explicit age-based restrictions on some voting process. And people of a certain age get to do one thing. People of a certain age get to do another thing. All three of those courts found that those procedures should be struck down under the 26th Amendment. There's also a case out of Texas involving Prairie View A&M. Prairie View A&M gets sued, seems like every 2 years. I've sued them a few times. The Department of Justice has many times. Not the university, the local county there, Waller County, that is always attempting to try to prevent students at the historically black college from voting in Waller County. So there was a case in the 1976 or so, 76, 79, that was brought by the United States Department of Justice. And what had happened there is Waller County and the state, with the state's consent, were trying to ask students to fill out a questionnaire to sort of prove that they had actually moved to Waller County and weren't intending to return to their parents' home or someplace else. as a way to sort of sift through who could register to vote in Waller County. A special 3-judge court was appointed. Back then, that was much more common than it is now. And that 3-judge court struck down the provision. They applied what we call strict scrutiny. And then because it was a 3-judge court decision, it was appealed to the U.S. Supreme Court, and they summarily affirmed it. This is called United States versus Sims, is the summary affirmance that the U.S. Supreme Court did. So those are some of the major cases that sort of directly deal with age. There are others. There was some post-enactment or ratification cases, district court cases around the country. And then recently, a couple of years ago, there's one in Florida that involved 26th Amendment claims where the court applied what you would call heightened scrutiny. So the claim here is that if the state wants to restrict some portion of the electoral process on the basis of age, then it has to at least meet strict scrutiny. We're arguing in our papers to the U.S. Supreme Court that this type of arrangement where people over the age of 65 get a voting vehicle, people under the 65 don't, that's not even a scrutiny analysis. It's just outright banned by the 26th Amendment. The same way the 15th Amendment would ban allowing African Americans or requiring them to vote in person and allowing whites to vote in person and vote by mail. And the same way it would be true if we said women can vote in person and must vote in person, but men could vote by mail and in person. That would violate the 19th Amendment. So Danielle has a case at the moment that I'm just serving in the dugout on in Florida that addresses the 24th Amendment, which is payment of taxes. And the argument there is that you can't be required to pay a fee to vote. And it's not even a matter of scrutiny. You just can't do it. So that's what we're saying the 26th Amendment means. It's written in the same language. It borrows its language from the other voting amendments that I've mentioned. And so it ought to be construed the same as those amendments. The Fifth Circuit's position was McDonnell has decided, whatever the age restriction issue is, McDonnell has decided you have no right to vote by mail. And so that injury can't form the basis of a constitutional harm under the 26th Amendment or any other. And I think that's nuts. I think if the legislature of Texas had said older voters are more susceptible to being taken advantage of and voting by mail, so we're going to require all voters over the age of 65 to vote in person to make sure their vote's not being manipulated, but we're going to allow everybody under the age of 65 to vote by mail because we don't have the same concern with them, that would absolutely violate the 26th Amendment. But under the Fifth Circuit's opinion now, the Texas legislature would be free to enact such a restriction. So in no other area of the law would you apply this rational basis review. And then the final thing I'll say about it is under the 14th Amendment, you already had a rational basis review for age-based restrictions. So under the Equal Protection Clause, before the 26th Amendment was even talked about, you would have taken an age-based restriction on voting and applied a rational basis to it. So if the 26th Amendment's adopted after that, the argument is it was done for no reason. It was unnecessary because the 14th Amendment already provided the protection that the Fifth Circuit claims the 26th Amendment provided. So we think that doesn't comport with either the intent of the amendment and the U.S. Supreme Court's jurisprudence on the voting related amendments. So that's kind of the central argument.
I only have maybe 2 additional comments about how crazy the reliance on McDonald is, I think, to decide this case. At least at the stage. One is that we've worked on a ton of absentee ballot cases. As I was talking about some of the more, courts routinely apply scrutiny to how the vote by mail is doled out once vote is an option, right? So courts across the country over and over again have said, notwithstanding McDonald, it has to comport with the Constitution. The lines that you draw about who gets to vote by mail have to be constitutionally drawn and have
Danielle,
to be constitutional.
Yes. Danielle, you're breaking up just a little bit.
Oh, okay. I'm sorry.
That's okay.
Any better? Not really.
The sound keeps getting louder and softer, so maybe closer to the microphone.
Okay. So I'll just say every court that has looked at absentee ballots has routinely said once you are extending the right to an absentee ballot, you need to do so in a way that is constitutional in divvying up those lines. In fact, the Sixth Circuit, looking at an early voting case, which is very similar and comparable to absentee ballots, has said, you know, you can't have early voting for some people and not early voting for others in a case about Army officers and those serving in the military. Kind of voting analysis that you would if it was voting on election day. So the McDonald analysis is wildly outdated and doesn't stand for what the court said it stood for. Second, even McDonald was followed up shortly thereafter by a case about prison voting that said, well, if there isn't other voting options available, then of course you have a claim. And so in the context of pandemic, we have to think about whether or not voting in person is a constitutionally adequate option for everyone. And I think it plainly is not. I think the emergency that Texas is currently facing, a new executive order today recognizing that, is enough to say that voting in person is not constitutionally adequate. So even putting aside some of the arguments that Chad made about kind of the facial 26th Amendment issues, the way that the court looked at McDonald was kind of flawed from the beginning.
Wow, that's really interesting. And all of this is moving so fast. It'll be interesting to see what is the ultimate decision when it eventually makes its way to the Supreme Court, which I assume, are we all on the same page that this is going to be an issue that they'll decide eventually, or might they punt?
Well, I think they will ultimately have to decide a 26th Amendment case. It doesn't necessarily have to be the Texas case. I mean, one of the things that happened in the voter ID case that Danielle and I worked on together is it went up in a similar posture as this, and the Supreme Court issued an order essentially denying, or I mean, it didn't essentially, it did. It denied all relief without prejudice, so we could come back and refile it if the Fifth Circuit hadn't taken action by a certain date. And that was widely read by us, and I think by the court, as an indication of, we're not satisfied with how you've handled this. You've got a deadline to handle it by, and if you can straighten it out, that'll be fine with us. But if you don't, then we're getting involved. So it's possible that what we see is something like that in the next few days. And of course, it's possible the court gets involved, and it's possible the court just says, no, this is not our problem to fix. But there are, I think, 24 26th Amendment cases pending around the country now. The vast majority of those are pandemic inspired, at least. So I think at some point the Supreme Court's going to have to give direction, whether it's in a stay application or in a full merits review on the 26th Amendment.
I think that's right. I think it would be irresponsible for the court not to try to give some direction before November. We're coming up on an enormously consequential presidential election in a context that the country has never seen before. And it, is incumbent upon the court to provide some sort of direction so that we don't have kind of different constitutional standards, depending on what circuit you live in under these circumstances.
Speaking of providing people with direction, that actually leads me to my next question. So since voters right now in Texas are already able to apply for a mail ballot for the July 14th runoff, and given the recent decisions and kind of lack of clarity with regard to who is and is not allowed to vote by mail in Texas at this time, what do you suggest voters do who are concerned for their health and might be hesitant to go to the polls? And specifically, is there anything they should not do?
Well, look, that's a tough call. I mean, what I would first suggest for them to do is contact their local election administrator, because there's 254 counties in Texas, and the Texas Supreme Court decision seems to leave some discretion. It leaves quite a bit of discretion to the voters and some to the election officials. But, look, it's an agonizing choice. I mean, I'm not going to try to sugarcoat it. If you're at home and you've got diabetes right now and you're under the age of 65, there's no clear answer to you in the Texas Supreme Court decision as to whether or not you're allowed to request a vote by mail. And, not to bring concern to anyone, but there's no sense in beating around the bush. The Attorney General has threatened to prosecute people about this very issue. So this is why we think the federal case is critical. And it's why we think the U.S. Supreme Court has to get involved. It's voters are in some jeopardy. But the best advice I can give you at this moment, before the courts finally sort this out, is you got to get with your local election official and get the best direction you can get there.
Yeah, that sounds right to me. I do. That's one of the practical considerations that should really be driving the Supreme Court, is that the Texas Supreme Court has led, there's legal reasons why the court should get involved, which I think Chad outlined exactly right. But there's also kind of the practical questions of whether or not the court is going to allow a circumstance where voters are in such uncharted territory without any meaningful guidance, without the clarity that voters really deserve as to what their voting options are at the very least. And so I think there are both, practical and legal reasons why the court should intervene, and hopefully we'll find out soon whether or not they're going to. But in the meantime, it seems like Chad's advice is all we have to give.
So given that, if voters go to the polls in person, what kinds of things should they expect, or what kinds of procedures are you hearing about being put in place to try to keep them safe if they have to go to the polls and vote?
Well, that also, unfortunately, is going to be down to their individual county. And I suspect you're going to see some counties that do a good job of it, and you're going to see some counties that don't. The Secretary of State's office has put out a couple of advisories now that are really just that. They're advice on how you can secure local in-person voting. And, in my opinion, even the advice is wholly lacking in some of the basic things it would need to have. It doesn't even require mask wearing, for example. It asks voters to bring some of their election equipment with them, like a marking device, and their own mask and hand sanitizer and other items. It's clearly, it seems to me, as a set of procedures that we want to do if we didn't want to actually spend any money and take responsibility for the problem. So essentially the state's position is, here's some great things you could do. Hopefully the counties will do them. And it's not clear at all there will be any money to support it. In fact, it's more likely than not there won't be. So that's why in Texas, at least, it's absolutely critical that Congress pass a bill. I know the House has already done its work and approved a bill that includes money and direction on this voting, at least for November. Won't do us any good for July. But absent some federal legislation, it's really going to come down to your local county, the extent to which they make your in-person voting safe. And I'll just add sort of one observation, right? You mentioned at the outset, Sandra, that the governor had moved our primary. Mm-hmm. And, the irony is we were probably better off having it when it was originally scheduled. I mean, the number of cases are so much higher now than they've ever been in the state that it turns out putting it off, although it seemed like the right decision at the time, ended up being the wrong decision. So look, I'm quick to criticize Texas about how it handles voting, and I will continue to do so. But the reality is, with this pandemic, there's a lot of things you can know and don't know. And I really do believe that people are trying to make the best decisions that they can. But the decision, at least so far, to not put real money and real teeth behind in-person voting restriction, or not restrictions, but policies for July and November is, I think, going to prove to be a disaster.
Yeah, I mean, the only other advice I could give individual voters is, to consider early voting, try to consider times that are likely to be crowded, and that you have the flexibility to vote then, maybe even ask your local election officials, are going to be the times that'll be less, trafficked or whatnot. And of course, wear a mask, it's not required. You're not only protecting yourself a bit, but more importantly, protecting your neighbors and your community members. But I couldn't agree more that what I think Chad said about it turning out to be the wrong decision, and that we're going to face a harder problem with the primary now in Texas than we would have a couple of months ago, is why we can't adopt a wait and see approach to how we look at November, right? We're not moving November's election. We don't know if it's going to be better or worse in November. And probably, maybe in some places it'll be much better, and in other places it'll be much worse. And it's impossible to know, which is why we need to have kind of prepare for the worst scenario planning right now for November. And this kind of wait and see approach that we keep seeing over and over again, that we saw in Wisconsin and Georgia and now Texas, is just not workable for November.
So Danielle, you mentioned Georgia. what kinds of things have you seen occur in states that have held elections between March and now that are concerning to you and that you're concerned might happen in Texas that we specifically need to be aware of and think about and plan for?
Oh, so many, unfortunately. So one thing, and the reason I raised early voting is election day lines have been extraordinary, right? And for obvious reasons, which are that the importance of mail-in voting is not only important for the people who get to vote by mail, it's also important for how it alleviates pressure on in-person voting. We are going to have some in-person voting, but without a functional and robust vote by mail program, we cannot process the voters that we need to be able to do so in person. It's incredibly difficult right now to recruit poll workers. It is incredibly difficult, all sorts of election staff going. States have had to reduce their polling location dramatically. And the result of all of that has been extraordinarily long lines, right? You had voters in DC and Georgia voting well after midnight, waiting in hours and hours and hours of lines, lots of voters leaving. And so I'm very concerned about kind of long lines. And so I think where you can utilize early voting to try to take some pressure off of election day, you're really serving yourself, but your community. Election administrators that I think are working really hard with the very limited resources they have. Another issue that led to longer lines was absentee ballots not being received in time. Folks are really struggling to process the increase in absentee ballot applications. Even with the stay in place, you can imagine that vote by mail is going to skyrocket in Texas, and some counties are going to really struggle to process. So getting your vote by mail application, if you can vote by mail, in early, so that you have lots of time for it to kind of get through the process and get through the mail, is another really serious issue. And then the last issue is, even if you get your vote by mail on time, some states have, received by date requirements. And Chad, you can tell me, is Texas one of those places? I think it is.
Yes.
Yep.
July 2nd, I believe, is the date for this runoff.
Yeah, exactly. So you have to have your absentee ballot received, not just postmarked by the date in question. And that's a huge problem because it basically puts you at the, at the whims of the USPS. And I have no doubt that USPS is doing its very best, but I'm sure anyone who's watching the news knows that it's, really struggling right now. There's a lot of delays, and we saw in places like Ohio, tens of thousands of ballots were postmarked on time, should have made it, and were found later and were not counted. So, the processing of absentee ballot applications in a timely manner that's going to make sure that those ballots count is something that I'm really anxious about.
So Chad, Texas specific, are you hearing anything from on the ground right now here in Texas that has you particularly worried other than the usual?
Well, yeah. So, it's really everything. We already had long lines in the March election. If you remember, we got national attention for, multiple hour lines, especially at Texas Southern University, the historically black college and university in Houston, where people were lined up until after midnight to vote in a primary election. So you can just imagine what we were in store for in November. And it really is a perfect storm. The state also has gotten rid of straight ticket voting, and this will be the first presidential election that has taken place without it. That may not sound like much to you, if you live in a rural county, but if you live in Harris County, often there's 60, 70 judgeships up for election. You'll have a ballot, if it were in paper, that's 30 and 40 pages. And so now folks are going to have to go, if they vote in person, they're going to be using an electronic machine, and they're going to have to go through race by race. So even if they want to vote straight ticket, they're going to be put through this exercise. It's going to take several minutes. And those minutes add up, right? Every minute you spend at that machine is minutes that other voters can't. So that's going to be an issue. Of course, things are going to be slowed down by the measures that they reasonably undertake to protect voters from the coronavirus. And there's also the concern of recruiting election staff. As I mentioned, we already saw back in March that election staff were concerned about coming in. Some states have designated certain state employees who otherwise don't have responsibilities during the election to be election workers. Unfortunately, that's a measure we haven't taken. There's still an effort to find voluntary poll workers. I hear in various places that they're overwhelmed by the number of people who want to be a part of trying to preserve our democracy. But at the same time, I hear in other places there is a real concern they can't get enough folks. Early voting, of course, is going to be a challenge in terms of the number of locations. I mean, as Danielle mentioned, I 100% agree. We're encouraging people, you got to vote early. Please do not wait for election day. But the staffing and the assignment of machines and locations in early voting are always set on past behavior. Trying to predict what's going to happen this November is nearly impossible. And for election workers to try to determine how many early voting locations they need, how many machines to have at them, and that sort of thing with the limited funding that they have is going to be a challenge. So, and then we're also unfortunately hearing that because a federal consent decree has been allowed to expire between the Republican National Committee and the Democratic National Committee, that there's now army of poll watchers that are going to be in place at these locations that of course themselves are potential virus carriers, and then are also have been in the past anyway, trained to be disruptive, to slow down the voting process, and to do that at polling locations that are more often voted at by African American, Latino, Asian American citizens. So there's a lot to be concerned about, and I wish I could put it a different way, but frankly, there are forces in Texas and other states that just don't want certain people to vote. And so it's on us right now in the court system to get as much clarity on these rules as we can. And then it's going to be on all of us as it comes up to volunteer, as a poll watcher, as a worker, encourage your neighbors and friends to vote early, vote by mail if they're allowed. We've got to, flatten the curve on in-person voting on election day. As many people who voted in person in Texas and everywhere else on election day in the last presidential election that number needs to get reduced, either because they voted by mail or they voted early. And all of us can play a role in that, either by doing it ourselves or encouraging the ones we know who are eligible to do it.
That is the perfect segue into my next question, which was, you mentioned poll workers specifically and people offering to work the polls for the election. That's always something that's needed because we always have a shortage of poll workers every election. But in addition to serving as poll workers, what are some things that perhaps specifically people who are lawyers or law students could do that would be helpful in the coming July election and the November election that they could volunteer to help with?
I mean, sign up for nonpartisan election, right? I imagine that the Lawyers Committee's election protection program might have similar kind of struggles to the poll worker recruitment. And we want to make sure that we do have folks on the ground that are really focused not on intimidating voters or disrupting the process, but making sure that problems get reported and that knowledgeable people on the ground are able to kind of explain what the rules are. There are a number of places where kind of knowledgeable advocates at the polling locations have already made a really big difference. In Georgia and DC, there were a number of polling I kind of wanted to close down, even though there were voters still in line that had been in line when polls closed. And it was only because there were voters and advocates there that were unwilling to kind of allow election officials to buck the rules and close polls. Those voters all got the opportunity to vote. Volunteering pro bono, if your firm is able to do so, groups that run election protection. I mean, in Kentucky, there were those voters who were waiting outside, waiting for a court order that would allow them to go back in and let them count their ballots. Along the lines of what Chad said about kind of, it's on everybody to kind of encourage people to vote by early, vote by mail when they can, et cetera. The one thing that has moved me, despite the kind of outrageous burdens on voting that we've seen, is that I think Americans are stubborn in protecting their own rights. even though voters are facing enormous challenges that they should not have to face. What I really found inspiring was how many voters did sit around and wait for 3 or 4 hours. Should they have to? Absolutely not. Is the fact that they were willing to do so patriotic and shows they're unwilling to kind of allow vote suppression to win? Absolutely. And, and there were folks, bringing them waters and Gatorade, and all of that is outrageous, and we should be angry. To see folks refuse to kind of let vote in the long run, and I think we're going to have to see a lot come November.
Indeed. So bit of a shift in gears. So have either of you noticed any issues with not just the lack of information and clarity and direction, but the spread of misinformation this election cycle in particular, making things even more problematic?
Well, I know that, for example, for some period of time there, and seems to be some evidence that our state attorney general was approving it, but Republican candidates were sending out mailers telling everybody without regard to age that they were all allowed to vote by mail. And so it looked like there was going to be sort of this process where people were going to look the other way if Republican campaigns did it, but if other Democratic campaigns or otherwise did it, then there was going to be issues. So we've already seen that. That's some evidence in the federal case that's pending now. But look, every cycle we see, handouts put on people's windshield, come vote this Saturday, gives them the wrong election date, tells them that there's going to be long lines. We have King Street Patriots is based here in Texas. It's an organization, in my opinion, that is organized to just harass voters. So I think you're going to see some of that. You always do.
Yeah, you always do. And I am afraid that maybe voters are going to be a little more susceptible to it than usual because there are so many legitimate changes happening to our elections, right? So folks who are used to they do the same thing, every year they go to the same and at the same time to voting, and there are going to be a lot of real changes to voting that are legitimate. Changes to early voting hours, etc. With that, I think that has the potential to create confusion and for folks to capitalize on that with misinformation. And that's why it's all the more important that these real changes, these kind of legitimate changes, be adequately publicized. I'm very the relatively lackluster efforts of states so far to communicate changes in polling place locations. And so in order to kind of counteract the increased potential for misinformation to kind of really make headway with voters, we really to, voter advocates, but more importantly to the state to make sure that they're communicating with voters even more than they.
Gotcha. So let's see, questions from the audience. So what's a voter's recourse to prevent election workers from closing if voters are still in line?
Well, I mean, they can file a state court lawsuit or even a federal court lawsuit about it. Fortunately, knock on wood, that's not something I've seen in Texas. If you stand, we have an explicit provision under state law that says if you're in line prior to 7 o'clock, then you have to be permitted to vote. But if you are kicked out of line, you should ask for, and you're told you can't vote, you should ask for a provisional ballot at the minimum. Some cases say you have to ask for it. I think that's wrong, but you should just try to. So, and then, you should report to either one of the political parties, to your county attorney. You can report to CLC or the ACLU or Texas Civil Rights Project or some other group. They all have hotlines and, try to advocate on your behalf. But the reality is if you don't cast a vote at a polling location and or a provisional ballot vote, you're not going to be allowed to later, regardless of what some court finds about whether or not you should have been kicked out of line.
Yeah, I mean, I think folks just have to demand, refuse to leave, demand your vote, call 866 our vote is, the, traditional election protection hotline, or any of their organizations that Chad mentioned. There are on the ground election protection whole networks that are designed to make sure that these types of kind of day of problems don't prevail. There are almost always election day lawsuits to polls open longer when there's kind of delays in opening, or natural disasters, or any number of issues that kind of make it such that it would be unfair to hold voters to say the 7 p.m. close time. So I don't suspect that, if voters are willing to stick to their guns and demand their rights, that there's going to be too many election officials that are going to truly kick them out of line if they were in line on time.
Excellent. And
Yeah,
then,
just to add one thing, in Texas, the practice is they come out at 7 o'clock and they hand a card to the last person in line. So there's usually a pretty good tracking of who's in line at 7 o'clock.
Gotcha. And how much of what we're seeing in terms of the problems happening with elections this year, other than the coronavirus issues, how much of what we're seeing would not be happening if the Supreme Court hadn't gutted the VRA?
A lot.
Yeah, go ahead, Danielle.
I mean, I'm not sure I have much more to say about that, right? I mean, so Texas wouldn't have been allowed to make any of the changes it's made in recent years to its election laws without getting pre-clearance from the Department of Justice. Now, of course, they would have had a friendly Department of Justice in recent years, in the past 3 years, but the standard was relatively high, and you have to show that it would not harm minority voting rights, and something like the elimination of straight ticket voting. The evidence was just extremely clear that it would cause retrogression in access to voting rights for minority communities. So I think it's obvious that most of what we've seen in changes in Texas have been for the worse for minority voters in recent years, and would have had a hard uphill climb if we still had the Voting Rights Act. The only other thing I'll say about it is I actually think that the loss of preclearance in the time of coronavirus is particularly, I think, highlighting the loss, right? Because we have all these fast changing election procedures, closing of polling locations, et cetera. All this is happening at warp speed. It's being done without a ton of oversight. And what we've seen in election over election so far is that minority voters get the short end of the stick when these changes are being made. Even kind of fast turnaround changes would have required pre-clearance, which would have required state election officials, when they were making changes, to think about how are we going to get pre-clearance for this? How is this going to be something that's going to get through? They would have to think about ways that they could prove that they weren't hurting minority voters while responding to the pandemic. They haven't had to do that, and the results have been pretty obvious.
Indeed. So we are almost out of time here. So if either of our panelists have any final thoughts, if y'all want to go ahead and cover anything we haven't covered that you think is important to talk about.
Well, I can start by saying, look, don't let this discourage you from voting, and don't let your takeaway from this talk today to be, wow, it's just too hard and I'm not going to bother. There's a lot of people, an army of some of the highest quality lawyers I've ever had the pleasure to know, that are out there doing everything they can to try to fix a lot of these problems. If you don't talk about the problems, identify the problems, then you're not going to fix the problems. But at the end of the day, we are going to have a democracy. I mean, at the bare minimum, we're going to have enough states that have 280 electoral votes that are going to have an electoral outcome we can have confidence in. And my guess is the Supreme Court will do just enough at the minimum to ensure that all 50 states are some sort of process that we can respect the outcome of. So go vote, tell others to vote, be wary of what we've explained in terms of trying to vote early, try to vote by mail, try to take the demand off of in-person voting if you can, but let your voice be heard, whatever it is.
Yeah, I mean, that's what I was gonna say too, really, is this has all been doom and gloom, which is what Chad and I tend to traffic in sometimes. It's lawyers' jobs to worry about all the ways things can go wrong and try them. And no doubt there will be things that go wrong, and there are things to be angry about. But at the end of the day, we're still going to have a democracy, and the democracy will be as good as the Americans who are willing to stand up for it. And on that score, we couldn't be doing much better. We've got extraordinary efforts, and people really focused on this issue. As somebody who's been working on this issue for a long time, I can tell you the energy and the kind of like awareness of voter suppression in America has skyrocketed, and that's made a big difference. And my firm is I am overwhelmed, like really overrun with law firms reaching out to CLC, wanting to do their part. And that's been really inspiring as well. You know, and I get follow-up emails, like, you haven't responded to my email yet about giving me a pro bono case. Folks are energized, and I find that really inspiring. So, you know, try not to doom and gloom from Chad and I too seriously.
That's always doom and gloom, so I'm used to it. That is an excellent positive note to end on, Danielle. Thank you so much. Thank you both for being here. And for those of you who participated, who maybe weren't able to catch everything because you had other things going on in the background, we have been recording this presentation. It will be available later on YouTube. You'll get a link to where you can find that. And tell a friend to watch the presentation, join ACS if they are interested, get involved in the election process, be an election worker, help with voter protection, spread correct information about voting procedures so that everybody knows what's up and can be as prepared as possible. And thank you all, panelists and participants alike, for everything that you are doing to help protect our democracy. Thanks so much.
Thanks for having us.
Good to see you all.
Good to see you.